We are profoundly delighted that today we have a persona like Dr. Pankaj, Additional District and Sessions Judge, Faridabad, the former Director, Center for Research and Planning, Supreme Court of India, among us for his deliberation on such a relevant and contemporary aspect, gender justice and jurisprudence of Supreme Court of India. He is a blend of bright experience of practice at Bar of Punjab and Haryana High Court, Chandigarh, by dealing with a huge number of cases with excellent academic career, including teaching experience at Punjab University and Army Institute of Law, with further experience of serving at bench as judicial officer, being a member of Haryana Judicial Services at a very young age of 36 plus. As a judicial officer, he brings glories by expeditious disposal of 25 sessions trials in January 2019 and 36 session trials in July 2019, while posted as an additional district and sessions judge, Hisar. This is the highest ever rate of disposal of sessions trials in a month in India till date. So, sir, we are very eager to listen from you, so I request you to please come.
I am beholden to Honorable Justice Surekhan Ji, Judge Supreme Court of India, Shri Tankeshwar Prasad, Vice Chancellor of the University, Professor Sunita Srivastav, Professor Sunil Kumar, Registrar, Head of the Internal Complaint Committee, and all faculty members, deans, heads, administrative officers, organizers, and students. My today's topic is gender justice and jurisprudence of Supreme Court. Jurisprudence is the subject which always gives us opportunity to research. It is the only subject which is never complete. Different theories, different thinkers, different philosophers, different jurists always provide different platform for research in law. And constitutional expectations, it may be the framers' expectations, it is also the expectations of the public from the constitutional authorities, it is the expectation of the institutions from the institutions. These expectations mandates to develop our own jurisprudence so as to fill the lacunas or gap between legislation and judicial system for progress of society, to develop society, and to protect society from time to time. Apex Court has always taken the responsibility of safeguarding any particularly vulnerable class of the society from inequality or oppression. From time to time, Supreme Court has developed its own jurisprudence we can say Indian jurisprudence. Constitutional provisions are only guidelines, and that guidelines are for the purpose of fulfilling that expectations which society has from this government, we can say, from these institutions, including educational institution also. Now coming to the topic, women in our country somehow, somewhere have always subjected to various oppressions. And there are numerous situations where fundamental rights such as equal treatment, equal opportunities are being denied. And because of this, talent of the particular section of the society by which they can contribute in different institutions remains ineffective. There is harassment, there are so many difficulties for female to come and give contribution of their talent. But Honorable Supreme Court, after feeling the situation, gave different judgments from time to time. Vishakha is one of the celebrated judgments. And this is celebrated judgment because it is not the copy of the right of any other country. It was the demand of our society which Supreme Court has provided. And only after this decision, this has been converted into legislative development by the Parliament. Not more going only on this Vishakha case, from time to time, to take the contribution of the female and to provide rights and protection. Supreme Court has developed its own jurisprudence. In Vishakha case also, in Vinita Sharma case, where the right has been given by birth to the female in the property. And that cannot be taken away even if it was prior to the case also. There was also recently a challenge in armed forces, there was no contribution. The Secretary Ministry of Defence case was decided and permanent commission has been given to the female and they can be promoted even to the extent of the highest in the forces. Therefore, Supreme Court has developed its jurisprudence to protect the particular section of the society, to uplift and to seek their contribution, to get their talent utilized. मैं जस्टिस सूर्यकांत जी के साथ मैंने काम भी किया है और from last 15-20 years when I was advocate, I started practice in 2004. I think in 2006 my one case was fixed. In that case there was NDPS case and one landlord has falsely implicated his servant, female servant, and all quantity has been imposed upon her. But that was a big quantity. I was a young lawyer. फीस कम होती थी तो उनको इस पे ट्राई कर लो, बेल तो होनी है. I took that case, filed that case, and fortunately that was fixed before the bench of Honorable Justice Sureka. On that day, I saw the sensitivity. I am certain I was not of such caliber, but that has been sensitively felt by the Lordship, and that has been mentioned in the case that female from depressed section has been implicated in this case. However, the landlord, land from belongs to that person, has not been involved even in this case, and bail was granted. the sensitivity of lordship and providing such type of gender justice. Now, I am further sure and confident that under the able leadership of Honorable Justice Suryakant of Supreme Court, he would further uphold the expectation of the people of this nation as enshrined in the Constitution, as discussed in the constitutional debates. Thank you.